Anyway, so the minimum, anti-Semitism was imminent in the United States and fairly well accepted. And the title of my paper, Gentleman's Agreement, the wonderful novel, shows the degree of subtle, rather than the kind of crude anti-Semitism that Sam was talking about. We're talking about a much more refined, high-class anti-Semitism. The next phase of my study is the demographics of the New York bar, which relies heavily on the demographics of higher education, in which anti-Semitism played its own distinct role. The first set of data I use are drawn from a study published in 1939 by Melvin Fagan on behalf of the Conference on Jewish Relations, and it was summed up by one Jewish lawyer's comment: "The practice of law is a dignified road to starvation." Slightly more than half of all New York lawyers, New York City lawyers in 1937 were Jewish. There were 22,000 lawyers. There were about 11,000 Jewish lawyers, of whom about 9,500 practiced in New York County. Law school was a direct determinant of practice status. 66.8% of these Jewish lawyers attended non-elite schools. And in the paper, I go through the income distribution and practice situation of New York lawyers, which I won't overemphasize here. But they demonstrate fairly starkly that Jews were overwhelmingly sole practitioners. Only 11% of Jews reported any kind of corporate practice, and that was almost exclusively close corporation practice. This data is kind of reinforced 20 years later by a 1960 study by sociologist Jerome Carlin, which shows where a lawyer attended law school, which was substantially dependent upon where he attended college, was the principal determinant of his practice status and income. Again, a couple of salient points. 70% of Protestants of high socioeconomic status attended Ivy League or other elite colleges. Only 34% of Jews of high socioeconomic status did. On the low end, 28% of low-status Protestants attended these schools, and only 9% of similarly situated Jews did, leading to the conclusion that a low-status Protestant was almost as likely to attend an Ivy League school as a high-status Jew. Why does this matter? Well, 77% of large firm lawyers attended Ivy League law schools, and only 20% of small firm lawyers and sole practitioners did. And attendance at an Ivy League law school pretty much required attendance at an Ivy League college. But it's not just about law school and college. Race seems to have played an independent role. Only 19% of Jews with a top education were members of large firms, compared with 45% of Protestants. As Carlin notes, a Jewish lawyer who achieved high academic standing, that is, staff of the law review at an Ivy League school, has no better chance of being at a large firm than a Protestant who did not make law review and attended a non-elite school. Well, there's a lot more I could talk about in terms of the data, but I'd like to now turn to the Chamber of Commerce report supporting the Act's passage, which I refer to as the Wood Report after its principal author, Franklin Wood, a founder of the firm of Hawkins, Delafield and Wood. Sam mentioned Louis Delafield before. Wood, among other things, was a member of the Bronxville Board of Zoning for 10 years. In the course of my research, I called the Bronxville town librarian to ask a little bit about history. And after we talked a bit, and I was quite frank with her about why I was calling, she reassured me that things had changed. She said, after all, one of our people is married to a Jewish woman. This was just a couple of years ago. In any event, I examined the Wood Report carefully and note the methodological flaws that lead me to conclude that 61B, or that lead it to conclude that 61B, the derivative statute, was the solution to abusive derivative litigation. I can't go over all of them, but suffice it to say the report doesn't even come close to proving its point. First, a survey of the law review literature from 1900 to 1944 shows only 44 articles, almost all of them student notes, even addressing the concept suits. The overwhelming majority of those had to do with directors' fiduciary duties and nothing to do with derivative suits at all, and half of them occurred after the 1929 crash, suggesting at least some timeliness. Students were trying to compete to get their notes in the law reviews, too. The most surprising aspect of the Wood Report is it concluded that derivative litigation was uncommonly frequent and uncommonly unsuccessful in comparison with absolutely nothing. It's especially striking when you note that there was comprehensive data on litigation in New York available. The Judicial Council of the United States started compiling and reporting data on litigation only 2 years into the 10-year period covered by the Wood Report. When this data is analyzed, and the Wood Report's analyzed alongside it, it seems clear that derivative litigation in terms of frequency and success was not in absolute numbers dramatically out of step with other kinds of litigation, and in terms of success and damage rates actually fared rather well. Derivative litigation constituted an annual average of 0.29% of all New York State litigation from 1935 to 1942, ranging from 0.22% at the low to a high of 0.41% of all cases brought in the first department, that is Manhattan, where the Jews practiced. More than half of these involved close corporations, with which the report wasn't concerned at all, leading to 0.12% of all lawsuits as derivative suits. Their success rates weren't so bad, and the paper has a lot of statistics supporting this. No careful reporter or reporter without an agenda would have ignored this easily available information if they were actually trying to write an objective report. Also striking, and this is after Mark's paper yesterday, is that while the report doesn't really discuss the backgrounds of lawyers, it makes a point of identifying plaintiffs and notes with great contempt the large proportion of plaintiffs who were women. It also turns out to be that it's not just women may be the new lawyers, be the new Jews, but of the 32 identified plaintiffs, 21 have obviously Jewish surnames, and another 7 have potentially Jewish surnames, making it 28 out of 32 plaintiffs that are Jewish. So I argue this is anti-Semitism, but simply noting the stratification of the bar and the clustering of Jews at the lower classes, combined with the disingenuous and deeply methodologically flawed report, it doesn't seem enough. So in order to reach my conclusion, I have to take 2 other steps. The first is to demonstrate that Jews, in fact, were the lawyers bringing the derivative suits against WASP corporations defended by WASP firms, and then ask why the defense bar wasn't as concerned with other kinds of litigation. And then the second is to refute some arguments that something else may have been at work. The evidence for the first conclusion, that it was Jews bringing the derivative suits and that the defense bar didn't care about other kinds of litigation, lies in the practice areas in which Jews were engaged. In 1937, the data showed that 42% of Jews represented merchants, another 25% a general clientele, and only 11% represented corporations. As I said before, these are mostly closely held corporations. In order to cross-check the statistics and the inferences that I'm drawing, I looked at every derivative suit case decided in the First Department between 1920 and 1944 that had a published opinion. I used the admittedly unscientific but unavoidable technique of identifying ethnicity by surname, a technique that I use rather self-consciously with the knowledge of the fact that Avram Mikhailovich Wasserman was granted the name Abraham Mitchell by a South African immigration official, but it was the best that I had.